Today, we will discuss some of the most common misconceptions surrounding Texas Senate Bill 140, which amended the Texas Deceptive Trade Practices Act effective September 1st, 2025, to make most spam text messages illegal in Texas. My name is Chad Cummings, and I'm an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at the university level and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Texas Senate Bill 140, which took effect on September 1st, 2025, is widely misunderstood even among attorneys, business owners, and compliance professionals. Many erroneously assume that it is simply a minor update to the existing Texas telemarketing laws. That is false. In reality, Senate Bill 140 represents one of the most consequential expansions of the Texas Deceptive Trade Practices Act in decades, reshaping how businesses can lawfully communicate with consumers by text message. The statute effectively redefines digital contact as telephone solicitation, pulling it squarely into the Deceptive Trade Practices Act enforcement framework. This change not only broadens consumer rights, but also introduces new substantial liabilities for nearly every company that markets by SMS or digital messaging. One of the most common misconceptions is that Senate Bill 140 is merely a regulatory rule and not a consumer protection law. That is incorrect. Senate Bill 140 embeds its provisions directly into the DTPA, meaning violations are treated as deceptive trade practices rather than minor administrative infractions. This elevates the significant consequences. When a business sends a prohibited text message, it is not simply breaking a marketing rule or guideline or suggestion. Rather, it is committing an act of statutory deception. This allows affected consumers to pursue statutory damages, attorney's fees, and in cases of willful conduct, treble, which is lawyer speak for triple damages. It also opens the door for injunctive relief to stop ongoing violations. The practical effect is that every illegal text message can carry with it a real financial penalty, making even small campaigns potentially ruinous for small businesses. Another misconception is that Senate Bill 140 applies only to automated or robocall style text messages. Another misconception. Many companies believe that they are safe if a human manually types or triggers the message. And this is a serious misunderstanding which stems from confusion with the Telephone Consumer Protection Act, or TCPA, which is a different law, which ties liability to the use of an automatic telephone dialing system. Texas lawmakers deliberately avoided that limitation. Under SB 140, the key question is not whether the message was automated, but rather whether it was a commercial solicitation. Any text message that promotes a product or service to a Texas resident without prior express written consent is considered a violation, regardless of the mechanism of transmission. Even one manually typed text message sent to sell a service or containing a hyperlink can trigger liability. Businesses also frequently believe that SB 140 applies only to companies located in Texas. That is a dangerous mistake. The law's reach is based on the recipient's location, not the sender's. If a business in New York, Florida, or even outside of the United States transmits a promotional text to a phone number of a Texas resident, Texas courts have jurisdiction because the harm, that is, the invasion of privacy, occurred in Texas. This extraterritorial reach ensures that out of state marketers and affiliate advertisers cannot avoid liability merely by operating remotely. A single misdirected campaign can subject a non Texas business to litigation in a Texas court. A fourth misconception concerns damages. Many assume consumers must show financial harm or emotional distress to sue. That is false. Like the TCPA, the amended DTPA provides for statutory damages per violation. Each unlawful message constitutes its own separate and potentially actionable offense. Typically, damages are anywhere between $500 and $1,500 per message, although every case is different and you should discuss damages with your attorney. The damages will depend upon whether the conduct was negligent, knowing, or willful, among other factors. This structure eliminates the need to prove actual losses in some cases, making the statute easy for consumers and their attorneys to enforce. The potential for aggregation, meaning hundreds of recipients each receiving dozens of text messages, can multiply damages quickly and send businesses straight to bankruptcy court. A particularly overlooked aspect of SB 140 is its new registration and bonding requirement with the Texas Secretary of State. This is a big one. With very few exceptions, any person or entity that makes commercial solicitations, including by text message, must register with the Texas Secretary of State and file a bond before initiating first contact. This is a continuation of existing telemarketing law, which has now been extended to cover text messages. Failure to register is itself a violation and can also serve as evidence of willfulness in an enforcement action. Many small businesses using third-party text platforms have no idea this requirement exists, and the vast majority remain unregistered. That ignorance will not serve as a defense. Another misconception involves the hours during which messages may be transmitted. Businesses often erroneously assume that they can send texts at any time because messages do not ring a phone in the traditional sense. SB 140 explicitly incorporates time of day restrictions, no messages before 9 a.m. or after 9 p.m. local time in the recipient's location, and none on Sundays or Texas state holidays. The law does not excuse mistakes based on time zone differences or automated scheduling errors. A business that sends out a nationwide campaign at 8:30 a.m. Eastern Time could inadvertently violate Texas law for every recipient. One of the most serious misconceptions involves opting out. Many companies think that sending a final confirmation message after someone unsubscribes, such as "We are sorry to see you go," is harmless. It is not. Under SB 140, once a consumer withdraws consent by replying "stop," any subsequent message is a separate willful and knowing violation. The same conduct also violates the TCPA's federal implementing rules, which prohibit post opt-out contact. Companies relying on third-party marketing vendors must at once ensure that those systems process and honor opt-out commands immediately and without delay, as even one residual transmission after withdrawal of consent can trigger substantiatory statutory liability. Some businesses mistakenly believe that non-commercial or informational texts are always exempt. Senate Bill 140 does not carve out exceptions for certain categories of messages, such as those that are transactional. But those exceptions, when they exist, are narrowly and strictly construed. A pharmacy reminder text about a prescription refill might be considered informational, but a follow-up message prompting flu shots or messages that contain mixed transactional and informational content may cross the line into a commercial solicitation. This is a major litigation trap for small businesses. Similarly, a church, charity, or political campaign may send certain texts without consent if the message is not for commercial gain. But once a message encourages a donation, sells event tickets, or promotes a paid service, the exemption could evaporate. The dividing line is not the sender's identity, but the message's content and purpose. Another misconception is that consent can be implied. No, there is no implied consent here. Many businesses assume that having an existing customer relationship automatically constitutes consent. Surprise, it does not. Under Senate Bill 140, consent must be express and written is a term of art which includes electronic forms, provided that they capture affirmative documented agreement with a date stamp and time stamp. Pre-checked boxes, vague privacy policies, or broad terms of service do not qualify. A business must maintain specific evidence of the consumer's opt-in consent for text communications. If a consumer later disputes it, the burden of proof lies entirely with the transmitter. Failing to preserve and produce this documentation is effectively fatal to any defense. There is also lingering confusion about the overlap between Senate Bill 140 and the federal TCPA, as I mentioned earlier. They are complementary, not duplicative. SB 140 provides additional state law remedies and applies even when federal law does not, such as where messages are manually sent or where auto dialer definitions under the TCPA are contested. Plaintiffs can sue under one or both statutes simultaneously, and each allows recovery of separate statutory damages, which are cumulative. Because the DTPA provides for attorney's fees and treble damages, Texas plaintiffs have every incentive to pursue both. Finally, some believe enforcement will be rare or limited to government agencies. Not true. We are pursuing several lawsuits on behalf of clients right now, and those clients are all over the United States. The DTPA grants a private right of action, meaning any individual consumer can file suit directly without waiting for state intervention. Moreover, because attorney's fees are mandatory for prevailing plaintiffs, lawyers have a built-in economic incentive to bring legitimate cases as long as they are non-frivolous. This structure mimics the TCPA's success in spawning nationwide litigation over unwanted calls and text messages. Early trends indicate that Texas courts will be seeing a significant increase in claims court and district court filings under the private right of action afforded by SB 140 beginning in late 2025 and continuing into the foreseeable future. In summary, SB 140 presents a major aggrandizement of consumer protection law in the Lone Star State. It imposes strict consent, timing, and registration requirements, eliminates the automation loophole, extends jurisdiction nationwide, indeed worldwide, and allows meaningful private enforcement. The most common misconceptions: that it is merely a marketing regulation or guideline, that manual messages are somehow exempt, that consent can be implied, that only Texas businesses are covered, or that damages require significant proof of loss are all wrong. The law's simplicity is what makes it dangerous. A single employee with a marketing app can trigger bankrupting liability for the entire company. Businesses must treat text messaging with the same care as financial disclosures or data privacy compliance. Ignorance of the reach of Senate Bill 140 is not just costly, it is now legally indefensible. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding the content of this presentation or of any of my earlier talks, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.